today, which is Changing Domestic Violence Order Conditions, What You Need to Know. I'm your facilitator, Catherine Gorda from Legal Aid Queensland's Community Legal Education team. Apologies that I'm off screen, but we do have three fabulous speakers on screen today, which I'll introduce to you shortly. I'll just start with an acknowledgement of country. Legal Aid Queensland acknowledges and respects the First Nations custodians of the lands where all of our offices stand, and we're joining you today from Meanjin and Brisbane, and where we work to help disadvantaged Queenslanders uphold their legal rights in our justice system. We pay respect to their elders, law, customs and creation spirits. We recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role First Nations people play in our community and in improving our legal system. So welcome. As I said before, today's topic is Changing DVO Conditions, What You Need to Know. And we are joined by three fantastic speakers today. We have next to me, Lavisa Lundberg from our family lawyer in our Violence and Prevention and Advocacy team. We have Sophia Kim, who's a domestic and family violence practitioner. And we have Caitlin Stewart, who is a Community Legal Education and Engagement Officer, all joining us today. Thank you so much for making yourselves available to be part of our webinar today. We have a trigger warning on screen because today's webinar will be touching on some sensitive topics. If you find any of this information challenging or require help, please contact Lawcare on 1800 177 740, and there are other supports available to you as well, including Lifeline and 1800-RESPECT. So a bit of housekeeping before we kick off with the content today. So this webinar is being recorded and the content is accurate as at today's date and is subject to change. You can find information about our webinar program on our website under the Community Legal Education Resources section. If you have any technical issues today, you will need to contact GoToWebinar customer support. Unfortunately, we can't help with technical issues during the live webinar today, but hopefully it all goes smoothly. So it is a 1-hour webinar today. The speakers will be talking for about 40 to 45 minutes. We'll be allowing some time at the end for a Q&A session. So if you do have any questions for the speakers today, please put them in the question box and we'll look at those at the end of the content today. We do have a copy of the PowerPoint slides available for you to download. They're in a section called Materials on your screen. Feel free to download a copy now, and we'll also share a copy when we share a link to the recording after the webinar today. So we're going to start with a couple of polls just to find out who's joining us in the webinar today, and I'll just launch them for you. The first one's asking what region do you work in, so I'll just bring that up. So there's 4 options: South East Queensland, Far North Queensland, Regional Queensland and outside of Queensland. And I'll give you guys 5 seconds just to pop your answer in and we'll share that with you all. A couple more seconds. Thank you, everyone. So it looks like most people are joining us from South East Queensland today, 65%, but welcome to everybody, including everyone from Far North Queensland and Regional Queensland, no one from outside Queensland today. And we do have another poll for you, and this is asking about what your role is, and I'll just launch that one for you as well. So the options are support worker, financial counsellor or health education worker, social worker, lawyer or other. So I'll just give you a few seconds to answer that one as well. And I'll share those results. So interestingly, we have almost 60% lawyers joining us today. Then the second highest category is social worker, then other. So that could be all types of different frontline workers, so welcome, as well as support workers and financial counsellors or health education workers. So thank you so much, everybody, for sharing that. That's really helpful for us to know. So I'm going to hand over to Sophia now to start the content. Thanks, Sophia.
Thank you. So domestic violence, as we know, can be seen as an umbrella definition of several different types of behaviours. And as a reminder, this slide shows the types of acts that are considered as domestic violence. There are more types of acts than the ones that are listed here as well. But we have used the Blurred Borders cards that can be a helpful tool to explain those types of behaviours during a consult with a client. You will see throughout this presentation that we have incorporated different blurred borders cards, and Caitlin will go through a case study and scenario later showing how you can use the cards with the client. So above, there are like some statistics about domestic and family violence, and it shows that at the current rate, domestic and family violence remains high, and it is statistically proven that men do perpetrate violence against their female partners or their ex-partners. What we will discuss includes an application to vary and how it can benefit and agree to further protection. I'll pass it on to Lavisa now.
Hi everyone, and thank you for joining as well. So this will show you an overview of what we will be discussing today. So this presentation has been developed following the feedback received and considered by different magistrates within Queensland that I frequently attend, but also some of my colleagues attend as duty lawyers in relation to application to vary protection orders or temporary protection orders currently in place. So there are two main types of applications to vary, and it's important to distinguish these two to assist the client in the best way possible. So Form DV4 is an application to use when the order is a Queensland order. So the order that the person, normally the aggrieved, wish to change is made in Queensland. This is the form that we want to use. Now, if it's DV4A, that application is used if the current protection order that someone wants to use was made interstate, and they are slightly different, and it's important to recognise the difference between the two. For the purpose of today, we will be focusing on the Form DV4. So, the application to vary DV4. This application to vary can be for the purpose of adding or removing conditions or exceptions. It can be to increase safety because existing conditions have been insufficient to protect the aggrieved and any named persons or children. It can also be for an extension of existing order if that's required, if the current order expires soon and has been a recent elevation of risk or the risk is still there. Those are good reasons as a basis for an application to vary to be made and can assist in keeping a person safe from violence and reduce the risk of future violence whilst holding the person who's using the violence accountable. It's especially in relation to the aggrieved, but also with correspondence that we will discuss both today. So the purpose of the application is to, if the circumstances change, an application can be made to vary an existing order. The existing order can be in a temporary or a permanent order form. So the changes that we can request to be made are adding or removing conditions, adding or removing named people, so children, relatives, or associates of the aggrieved. Increase or decrease the time that the order is in force. So, who can apply to change the order? An application to vary can be made by the police or in a private manner. The following people can apply to change the DVO. The aggrieved, so the person that needs protection or has needed protection previously, the respondent, a police officer, a named person, or someone chosen by the aggrieved to act for them that's authorised. So we have seen a pattern where the Queensland Police Service tends to apply to vary orders to increase conditions and reduce or remove exceptions due to an escalation of risk. These variations can stem from a recent incident such as a breach, and the police have assessed that the existing order was insufficient to protect the aggrieved and or the named persons or children. We often see, though, that it is the aggrieved that files the application to vary to add or remove existing conditions and the length of time. So the aggrieved tends to do, we've seen statistically that they file for a number of different reasons. Now, the court has pointed out that they would like to see that the respondents take more responsibility in filing applications to vary to reduce conditions, to put that effort back on them, to show that they have changed and considered their behaviour which resulted in the order being made in the first place. Now, there's also special rules in relation to named people. If the applicant to an application to vary is the named person on the order who's an adult, the named person can only ask to change the parts of the order that affects them. So, for example, a request can be to change the remove condition that involves the named person or stop the order from including them altogether. We don't see these too often, but they do happen. So what they can ask to change is, like I said on the screen, to remove their name all completely, because they don't think that they need protection and that police made an error originally if it was their application. Another scenario can be that the respondent, for example, is prohibited from approaching or communicating with the named person, but the named person wished to have contact with them. So in that circumstance, it can be that the good behaviour condition stays, but that they can't communicate because the named person doesn't feel fearful of them in that regard. Now, what the court will look for in relation to the application to vary. The Domestic and Family Violence Bench Book 2012 sets out that the court must have regard to the following. So any express wishes that the aggrieved or named person has, any correct contact between the aggrieved or named person or respondent, whether any pressure has been applied or threat has been made to the aggrieved or named person by the respondent or someone for the respondent, and the safety, protection, or well-being of the people who appear or experience domestic violence, including children, are paramount. So throughout duty lawyer services, we often see that the aggrieved application to vary can simply just state, because I need help with the kids, I need the conditions removed because his behaviour has changed and I need him home. Now, this is not enough information for the court to change their mind and reduce the conditions. It can be an indicator of what the views and wishes of the aggrieved are, which is good to know, but it fails to address whether the aggrieved and named persons will remain safe if the conditions are to be reduced. So the court wants to know more. So what will they look for? Like we mentioned, the court will vary the order only if the court considers that the safety, protection, and well-being of the aggrieved or named person will not be adversely affected if the variation is to reduce the duration of the order, and there's reasons for doing so. Here's the next slide of what the court will look for. So the court will want to know more in relation to the content of the original application for protection order to help them understand the background of the matter. If possible, the applicant who wants to apply to vary the order should provide the following: a copy of the original application for protection order, a copy of the current protection order or temporary order, any family court orders, so for example, consent orders, any Department of Child Safety letters or involvement. Now, if it is the aggrieved or the respondent that files the application to vary, either person can attend the courthouse before they lodge the application to vary, provide their ID, and request copies of the original documents. That will also be helpful for them to receive legal advice that's appropriate for them if they would like it before they apply to vary. The documents will be helpful to the court when reviewing the application to vary because it provides the background story and the foundational reasons for why they were there in the first place. It's also very helpful if the original order was made in a different court. So, for example, if the court was made in Caboolture, but they've now filed it down in Brisbane or Beenleigh, and the court doesn't have access to that file just yet. They will also want to know if anything has happened in family court and see if there's any contact, for example, between the respondent and the children and what that would look like, because that can impact the exceptions and conditions that they might be asking for. Now we're going to move on to the tips. So this is in relation to the actual form that we're going to look at, because we have seen quite a few errors happen throughout, which has not been beneficial for the applicant, but it's also to help the court in deciding whether any variation should be made. So this is what the front cover looks like. It looks very similar to form DV1, which is that normal application for a protection order. Okay. It's available on the court website in PDF or Word form. You can also get a printed blank copy from every courthouse, but the form is not very user-friendly, which has also been acknowledged by the court. I also don't find it very user-friendly, and I'm not very tech-savvy, so that doesn't help. So we are now going to provide you with options and examples of how it can be filled out to give any applicant the best chance of having the court understand why they want to change it. So, thank you. So I have a Jane Smith here who we like to use on a regular basis. So if it was to be a female, so they agreed, for example, in this circumstance, who wants to apply to vary the order, she will need to fill in her name and date of birth. But if the respondent doesn't know her full address or details, it is recommended and suggested that she can write confidential in that section that's highlighted on the screen for you. Now, if they want to do that, they can fill out a separate form, which is a court form called DV01C. So the court will receive their details, but the respondent won't, and they won't be disclosed and they will remain confidential. The reason being is if the agreed remains fearful and they are seeking to increase conditions and the respondent doesn't know where she lives, we don't want to let him know. We don't want him to find out and any of that. So we want to keep it as safe and simple as possible. Now, when it comes to John Smith, she can provide as much detail as she knows, but the more she knows, the better, but the police and the courts will have ways of finding who that person is, especially if there's already a temporary order or a protection order in place that would have some details already. So, there we go. This is page 2, so there's a few more details on this page. Now, when it comes to the applicant's detail, which is part 3 at the top, if it is the agreed or respondent that completes the application to VERA, then we'll leave this blank. If it's the police, oh, there's been a typo here. If it's a police or a named person that makes the application, that section will be completed. But if it's a private one, we don't have to worry about it. Part 4 is in relation to the existing order details. I haven't ticked this because we don't know what Jane wants to do or where she's at. So this is why it's important to see whether it's a current temporary protection order or a protection order in place, when it was made and where it was made. As you can see at 4A, the court or the form also asks for whether it was done prior to 2017. Now we are seeing this more and more rare because the order tends to be for a standard period of 5 years, but we still see them, so just double check. In relation to part 5, details of variation, we always suggest that you tick yes, but especially when it comes to their conditions. If it's just to the exceptions, you can tick no, but we recommend that you tick yes, and that will then indicate to the court what conditions, if any, that you are referring to. Now, this is something as well that not a lot of private persons know, but you can write here, please see attached as highlighted. And this is very important because, like I said previously, the form is not very user-friendly, so you can't always extend the actual spacing here, and that makes it very difficult for the agreed or applicant to explain why they want to have it changed, and it's not enough detail. And we will go through what that statement could look like a bit sooner. Okay, so as you can see at the top here, please see attached statement. That's the reasons that will continue over to this page. But again, it's not very big. And this is the misconception a lot of people think, is that they can only provide so much information on these few lines, but that's incorrect and hence not very user friendly. So they can write please see attached statement, and we will go through that as well. Now, when it comes to part 6, temporary protection order, this is also a common area with a private applicant to not tick yes in this section. We recommend ticking yes because it shows to the court that they want to have these changes considered as soon as possible. We also have section 7 a little bit further down. There's no notes on the slide for it, but as you can see, it says details of any other orders. So we want the applicant to go through these and look at whether any of them actually applies right now. So for example, if a respondent was subject to an intervention order in the past, they would tick yes. If there's any court orders, we would like to tick yes as well, family or court orders. Same with children's court orders. We want to have all of those ticked and provide the copies if possible. Now, when it comes to the statement that we were referring to and how you can write please see attached statement, the applicant can attach a separate Word document to their application to vary, which the magistrates and the other parties to the application can then read. This statement should include if the applicant seeks a temporary protection order and why. So, for example, if there is a recent elevation in risk and a recent breach, and they need urgent attention to increase conditions. They will want to know what has happened since the current order was made. They will also want evidence available to support the change. So that if you have evidence available, attach it. We also understand sometimes you don't have evidence available, but then you write down exactly what happened to the applicant's memory. Okay. So this is a statement example that we have provided to you guys. Again, we've used Jane here. And we always recommend that you write the date and their full name on the statement at the top. So just to make it clear that this belongs to her application, should those pages be lost and they're not stamped, for example, when they're lodged with the court. So as you can see here, it's a slight introduction and what she wants to have changed, because the respondent, John, has breached the order several times and she remains fearful and the order is about to expire. She has then done a subheading in relation to the temporary protection order, and it can be, for example, that she has lodged it on a Thursday. She's worried that the next week it's going to expire and she wants it looked at before it expires. She's also written the details of the variation. And when it comes to these ones, it's important to not provide an essay that's 2,000 pages long or 2,000 words long. 2-3 pages is plenty. Subheadings are great as well. The court wants to know what's the most recent incident that occurred and why it's really serious for it to be looked at as soon as possible. So this is a continuation of the statement. So Jane here has provided, for example, that he has interrupted her at work several times. She's fearful of wherever she goes. She's made a police report about it, and she's attached a copy of the statement to the police and also photographs of her injuries, such as the bruises. So this is where you can also provide the copies of the statements as evidence. Now, this statement doesn't have to be in an affidavit form or signed by a JP. It can be just attached to the application. Again, this is a common misconception. Affidavits can be used later in the court process. So what evidence can be included when it comes to adding conditions? So they are encouraged to attach evidence where possible, and we also acknowledge that sometimes it's not possible. For example, if the respondent takes their phone and everything was on their phone, so we acknowledge that for sure. But if there were physical injuries, photographs of the injuries, such as the bruising appearing a day or two later with date and timestamps, screenshots of messages between the parties. Now, the court has provided feedback that they want, for example, a full screenshot, not just picked out certain sections or messages. They want to see the full correspondence between the parties to understand how they normally talk and what is it that has changed. So, for example, is it a random threat or has it been ongoing? We can also sometimes attach statements of individuals if they saw an immediate incident and there's no other evidence. That's okay. Any medical reports if the aggrieved in the circumstance attended the hospital and got support for her injuries. Sometimes the aggrieved don't go to the hospital at the day of the incident, but go a couple of days later. They can still get a medical discharge letter. Also, copies of statements from the police about the alleged breaches. It can be that the police don't take out an application to bury given the breaches, but the aggrieved does, and you can still attach these statements, and that's important that they do because the court will want to know what's within those breaches and statements and what police will do. Now, when it comes to police applying for the application, it is important that to know that it's quite rare for police to seek a reduction in conditions. It's most common that they seek to add conditions and remove exceptions due to breaches. When it goes to court, and we'll talk about this more later on, the court will want to know the criminal history of the respondent if he's wanted for questioning, or if there's any alleged breaches up for investigation, or whether he's been convicted of breaches, and what those criminal outcomes look like. That's important for the court in order to assess the risk present and what's been and what the potential can be. Now, this is an example statement by Jane again on how you can set it out to remove conditions. The structure is quite dissimilar. You want to have subheadings in there and a bit of an introduction on what you want to explain. So, for example, you're seeking a variation to the current protection order against my ex-partner. So just set out very clearly what the relevant relationship is and what she wants to do. We also set out the temporary protection order, why she wants it. And this is not uncommon where we have seen, for example, they are wanting a temporary protection order with a written permission or consent to speak provided to the respondent and to speak and adjourn it for a period of time to see whether that trust and respect has been rebuilt with John and whether John will respect the boundary of written permission or not. We can then have the section of, again, details of variation. The current order, for example, here was made in 2022 at Brisbane Magistrates Court with very strict conditions. She's attached a copy, which is great. And then she also sets out that the family court proceedings about the kids has been now finalised with consent orders, and that has been provided as well. The court will want to know, for example, if the parties are meant to communicate by way of, for example, a parenting application only, and only by phone, for example, in emergency circumstances. That will help them understand what should and shouldn't happen in this jurisdiction as well. But it sounds like here John has been doing better, and that the agreed now wants to be able to communicate. She's not asking for the order to expire sooner. She's asking for it to stay in its place until 2028, but to reduce the conditions to work towards the co-parenting relationship. Now, what evidence can be included when it comes to supporting the removal conditions? So, for example, when it comes to respondents, and male respondents, have they completed a men's domestic and family violence program? There's a number of different ones out there, depending on your jurisdiction. We're evidently in Brisbane today and where we're from, but the Brisbane jurisdiction has a number of different programs, so does Beenleigh and so does Cairns as well. So it will be depending on where you are, but there's DV programs around, and there's now some also via online. We're also looking at whether the respondent, male or female, has completed, for example, an AOS program, if that's a contributing factor to why they behaved in the way they did in the start. So was alcohol or drugs an issue at the time, but now they have reduced their intake and they are behaving a lot better. Circle of security program, very good to use. Same with parenting programs, how they should and shouldn't behave in front of their children, how to communicate with them. Also very good and appreciated by the court to see. A letter from the psychologist as well, if they find that the other programs are not suitable and that it's more mental health based, that's also very good. Also a letter from, for example, their GP in relation to any medications that they're now and that they've been stabilised. Very much appreciated by the court to see what effort that they've taken. Now, it won't be necessarily enough with a letter from the psychologist saying he attended one session with me. One session here and there is not going to be enough normally. They want to see sustainable changes in their behaviour. So this is where we're looking at when it comes to breaches and criminal history. So when the court receives an application to vary, the court will request a copy of the respondent's criminal history from the prosecution. And you will normally have prosecution sitting in the DV court, and they are very good at providing these to the magistrate. They can also look at entries that have not been carried over yet to the person's criminal history or DV history. For example, any active investigations into alleged breaches. So this information will be considered when it comes to the risk posed by the respondent towards the agreed. So has there been a recent breach? What does it look like? What's the content of it? Or was it a long time ago? They will look at the violence, the level of violence, whether it was in-person breaches, physical breaches, threats, or let's say even sending letters that they shouldn't have. So there's a vast of different reasons, but it's important for the court to receive this and for it to consider it. Now, when it comes to police applications to vary, they tend to, in their statement, have a small section in their statement. So keep an eye out for that, and that can refer to if the respondent has previous DV dealings and criminal history in relation to domestic and family violence. Some police officers and stations are better at including this than others, but I'm personally seeing a much better increase in including this because that can help provide advice to the agreed about applications to bear in the future, and also how to walk them through this process. Now we're going to look at the conditions and exceptions of DVOs. Now, it sounded like quite a few of the lawyers are on here, about 60% I heard, so these are not going to be new to most of you, but we will walk them through again for those who might be a bit newer to this field, and just refresh your memory. So we have these here. Now, the good behaviour condition is always mandatory and will not be removed. What's positive is that you will now see on the orders that the good behaviour condition is quite long. You will have a sub A and sub B section, and that's to include the coercive control law wording that was introduced not too long ago, which is good to see. So we haven't spelled it out because it's very wordy, but you all know or should know what it looks like, or I can send it to you. That's not a problem. These are some of the very common conditions to use. So the ouster condition, the return condition, and the contact condition. I'm not going to read through all of them. It's quite a mouthful and we have a few to go through, but you can see them on the screen here. Then we also have these no approach conditions, social network and location condition. The social networking condition is not as common to use. And I've seen them from time to time, apologies, when the respondent has, for example, made some quite nasty statements on social media indirectly in relation to the aggrieved, for example, and publishing photos that are really inappropriate. So that, for example, can be a reason for including the social network. But again, when it comes to adding and removing conditions, you want to have evidence to support why. So it can't be a blanket, include all the conditions. We need evidence for each and every one of them. Thank you. Same with the school and childcare conditions, monitoring, tracking, and unborn child condition. You don't see them all the time, but you do see them. I also have a scenario coming up as well. The monitoring, tracking, we have started seeing where, for example, people have agreed to track each other on your iPhones. Some people don't necessarily agree to it, but don't feel like they can say no. That can then be a reason to include this, but it all depends on each person's circumstances. When it comes to the school and childcare and not attend within 100 meters, that can also be, for example, if it states that in a family court order, that can be quite relevant then. And that's why it's important also to bring over those orders from a different jurisdiction to show whether it complements or clash with each other. So this is an example in relation to the unborn child condition, which I want to walk through. And again, it's a trigger warning, but this is a matter that I had quite recently as well, and just an example of how you can use an application to vary. So in this circumstance, and as you can see here with the Blurred Borders cards, which are quite well laid out, so thank you, Caitlin. So in this circumstance, the police took out an initial application for a protection order, naming a female as the aggrieved and a male as the respondent. They had been married, but they didn't have any children yet. She was pregnant at the time that this DV incident occurred, however, and there was some physical violence involved. Now, she did not attend the first court mentioned when a temporary protection order was issued, and that one had quite a few conditions, but also exceptions to it. When she received this temporary protection order, she saw that the unborn child condition was on there. Since the original incident had occurred, this aggrieved had unfortunately had a miscarriage. So she contacted us and received advice, and she subsequently filed an application to vary with this court requesting to remove this condition because, one, it was no longer relevant, but also she did not want a reminder each and every time she looked at the order that she had had a miscarriage. The court didn't hesitate to remove this condition. They also removed a couple of other exceptions in relation to contact by the respondent to her about children. They didn't have any other children, so all of those exceptions were removed. She was very grateful of this, and no one hesitated to make it happen. So this is the exceptions that we're going to look at. There's a few. They are commonly referred to as the family law exceptions, and there's quite a few of them and quite wordy, but we'll go through them. Now, the ones that we will see quite commonly, for example, to use, or for example, refer to is, for example, exception D, except when having contact with the children in accordance with a prior written agreement. Now, a written agreement can be, for example, a parenting plan that's been made in mediation if that exception is available, which is exception C. Exception B is also very common to include, especially when there's other proceedings involved. So, for example, family court. They won't be in trouble by attending family court if they have to be there, and they can't not be within the 100 meters of the aggrieved. For example, being within the same courtroom. The courtrooms are not that big. Now, these are some more exceptions here. Exception F is not that common, but it's not uncommon either. So this is where it's important to canvass whether child safety has or is involved as well. Exception G is very common, and we see on a regular basis. So this is except when having the prior written consent of the aggrieved, including by text or email, which can be withdrawn by the aggrieved either orally or in writing at any time. This is also referred to as the written permission exception. Now, it can be, for example, that the magistrate is content with providing, for example, this exception to their parties being able to have contact with each other by telephone, or when the respondent, for example, is in a prison, but not when he comes outside. So you will see exception G used quite frequently in orders, very wordy, but they're quite good. In relation to exception H, that one is used also. Now you can see that it says, except when communicating with the agreed by text, telephone, or email. Now, family court orders, like I said previously, tend to use a parenting application as the best method for parties to co-parent, especially when there is some hostility around. So as duty lawyers, we do tend to advocate for the aggrieved to be able to communicate by a parenting application. Now, it's not available or set out on the form that we can pre-fill and hand up to the magistrates, but some magistrates have been very good to be collaborative and including, for example, except when communicating with the agreed by email and a parenting application. So they can set up that parenting application and then move over to that once they have chosen one and started using it. Then the respondent won't get in trouble and everyone understands what's going on. So when it comes to the application to vary court process, I won't go through it too much, given that it's not that dissimilar from the normal application for a protection order process. So as we can see here, the application to vary with any supporting documents needs to be filed at the Magistrates Court Registry. If it is police or private, police will have their own slight ways, but the registry needs to be informed in order to register it. Service also needs to happen, as we know, and then we'll be allocated a court date called a mention. Now, there was a today question that we received earlier in the week in relation to time frames, the turnaround time from when someone applies to vary to when things happen. Now, this will vary from each jurisdiction and area that you're in. So also when different courthouses sit. So for example, the Brisbane Magistrates Courts will have the court running Monday to Thursday, whereas Cleveland will have it every Wednesday, Richmond will have it every Thursday. So it will vary depending on where you are. Having said that, if a private application is submitted to, let's say, the Brisbane Registry on a Thursday, and the registry staff has a quick view of it and go, no, we're quite worried about this, they can then go and have it viewed by a magistrate and they can assess whether to file or have it listed on that first Monday morning. So they do tend to, from what I see, have a very quick turnaround time if there is a genuine concern about risk and if there's concerns about increasing it and they're not staying safe. They also are mindful of whether or when an application will be or an order will expire. So they don't want to list it after that it's expired. But it will depend. If it's not deemed too urgent, then you normally, or from what I've seen, it's normally about a 4-week turnaround time, depending on the list of each courthouse as well. So we can't speak to the internal processes, obviously, of each courthouse, but that's what I have seen as a duty lawyer, that it's normally, if it's deemed not too urgent, about 4 weeks. If it's deemed urgent, it's within the week, I would say, most of the time. Police applications tends to be listed within the week as well. Evidently, they can issue, it depends, but not necessarily the PPNs, but they will have them sort of push through and ask for it to be viewed quite quickly, especially if there's been a recent breach and, for example, a criminal proceeding has started, they will want to have it looked at as well pretty quickly. It is ultimately at the discretion of each courthouse and registry and the magistrates as well. And we do appreciate how difficult it can be for them to assess the need for urgency as well. Now I will actually hand over to Sophia.
Thanks, everyone. So when we work with clients, it's important to understand support extends beyond the initial engagement. And we all have to remember domestic and family violence requires responses beyond the legal system. As part of trauma-informed practice, practitioners should know services available to meet the needs of clients, whether they're a person using violence or person experiencing violence. If not, refer the client or provide information to them so that they can engage with appropriate services for the needs. Now, what is trauma-informed practice? It's a holistic approach that acknowledges the widespread impact of trauma and seeks to create a safe and supportive environment that empowers individuals and communities. So we would typically put priority around understanding and preventing the re-traumatizations. And as anyone who works in this kind of space, we should all engage in trauma-informed practice and generally through every client engagement. So magistrate courts in different regions work with different legal services and domestic and family violence specialist service that provides support for clients going through court. So for example, at the Brisbane Magistrate Court, we have domestic and family violence practitioners, as well as the duty lawyers from Legal Aid who provide assistance to clients, so including legal and social support. So the service is usually from Monday to Thursday when the DV court is running on level 6. And we would typically assist with clients going through court for safety facilities, advocating and liaising with stakeholders such as security, court registry, other duty lawyers, and so forth. Obviously, among other things, would be safety planning and emotional support for clients who are navigating through the court, and making sure that we can, if necessary, making direct referrals to services that client identified areas of support for. More specific to application to vary or application to protection orders, we do run a program called Application Assistance Program every Friday at the Brisbane Magistrate Court. And just a reminder that this is only provided for clients in Brisbane catchment area and for those who are applying in Brisbane Magistrate Court. Clients can drop in, I think if you could go back to the slide before. Yeah. Clients can drop in, so it's a drop-in clinic. We don't have they don't have to call and book an appointment ahead, so they can drop in between 9 to 1 o'clock and receive support around completing application for protection orders, application to vary, and depending on the capacity, support around legal aid applications as well. Now, during engagement, we would usually use risk assessment tools to map out risk posed and discuss safety planning with client, arrange support for next in courts, and make referrals to other support services, including housing, disability, victims assist, and so forth. Now, as I mentioned before, these are a little bit parts about domestic violence court support programs. And then if you go to the next slide, these are the domestic violence court assistance that runs from Monday to Thursday. And then our application assistance program, like I mentioned, is only on Fridays, 9 to 1 o'clock. Now, this is our little pamphlet. So if anyone gets lost or they want to refer a client, there's a little bit of a roadmap in there, so you can let the clients know. Otherwise, the Brisbane Magistrate Court is pretty easy to find. Otherwise, they can give us a call as well. While working with clients who present to vary the protection orders, understanding the impact of trauma when it comes to court events is very important. And remember that there is no fit presentation of what a survivor of domestic family violence looks like or should be. So we avoid re-traumatization as much as possible and try to minimize retelling of the story by working with services, and if referrals are being sent, making sure that the right information is included. So clients can sometimes present to you heightened or distressed, and to support as best we can, communicating with parties before the court Respecting the time for the services they need to engage with and to provide support, and liaising with other services to provide support is important as well. Now, when it comes to working with clients, try to use plain language when communicating with them and check for understanding of information. Don't forget it might be information that we know all too well or is common for us, but not to the clients. Understand trauma impacts one's brain and capacity to understand and comprehend information, and that is completely normal. Clients may be overwhelmed or might be in fight and flight mode, so be mindful and use languages, tones that are inclusive and culturally safe. Try to avoid using judgmental language as a tone, and perhaps think about the sentences that you use with clients and don't say why did you, and try to frame it in what happened. When working with person using violence, part of making changes for domestic and family violence space is to not align or collude with person using violence. So just be aware that image making, false narratives, not laughing at inappropriate jokes or statements made by people using violence is very important. Consider extra time or leniency when engaging with clients as well. And just know that people need time to process options. Additional time may be required if you're using interpreters or alternate speakers. Consider clients' needs, especially if they're neurodiverse, if they have a disability or chronic health issues. So for example, when working with clients who you identify that has a bit of special needs, think about working with stakeholders to make sure that the client has prioritization when it comes to court, make sure that they have the right access to support facilities, and so forth. Just remember that courts need to feel that they are being supported when it comes to the process like this. And part of supporting clients is about providing space for them to be heard and for them to make their own choice. Obviously, validate the experience as well. So they might disclose domestic and family violence events to you. So try not to discount the truth or minimize violence allegations when they do disclose those events. It's important to understand that safety is not a one-size-fits-all approach. So what safe means can be very different for everyone. So when working with clients, consider the barriers that they can face when it comes to seeking help or making changes. So for example, if you go to the next page, so things like barriers to seeking help could be hoping the abuse will end, isolation and dependency, cultural expectations. Obviously, these are not all of the barriers that a client can face, but they are some of the things. And just remember that every engagement you have with the client is important and can influence the future engagement for clients when accessing support. So it can make or break it for clients moving through complex legal systems and systemic gaps to continue reaching out for support. So let's all try to walk along the side of the clients and support their journey to heal. Now, one thing to consider is when it comes to when you're supporting clients, just think about when they do apply to extend, add or remove conditions, where does that leave the client? Make sure that you include the clients in terms of safety planning and ask them what can happen if situation like A arises. Consider potential risks when application is lodged, and other things to consider with the client could be, would the escalation of a person using violence be there? What are the systemic or financial impact, or what would happen towards children and their safety? Now I will pass it on to Caitlin.
Thank you. So I'm going to quickly talk about Blurred Borders Queensland today. You've probably seen a lot of the cards that have been embedded throughout the PowerPoint. Physically, we do actually have the cards here, but they can be downloaded off the website as these images. So we thought we'd try and tell the stories around DVO condition changes with the cards today. And I was going to use them to tell one more story that we have. Can you go to the next slide? Thank you. So I have an example that I just wanted to show how you can use the Blurred Borders cards when you're talking about your clients and potentially talking about what it might mean when you're changing DVO conditions. So for this example, I have a woman. We identified her as a First Nations woman. She's got maybe 2 or 3 children, and she had an ex-partner who has a DVO, and he had a DVO for behaviours such as stalking and threatening her and the kids and intimidation. So what did she do? Well, the DVO was coming to an end, so she wanted to seek a variance so it could be extended. So she went to her lawyer and she got granted legal aid to have a lawyer represent her in the magistrate's court, so she didn't have to attend. And she also got given support with the yarning circle. So we've got the social worker counsellor card to show that she got outside additional support, and the lawyer was able to support extending the DVO and changing the conditions. So the DVO conditions now include no contact online. Please do not ask people to break rules. So he couldn't ask someone that she knows to go and try and harass and threaten her. And also to make sure that the continuation of the order of staying away from some people, such as herself and her children. And we find that's just a really easy way that if you're working with a client that does need those exceptions change, and as we went through, it's gone through a whole hour of trying to explain what that means when it comes to DVO condition changes. This is a way to go, hey, this is where you're at, this is what's happened, and this is what can happen when we have a lawyer in a magistrate court and what more conditions could look like. So it's a really easy way to meet your client at their level, be able to explain some really tricky behaviours such as stalking and threats and intimidation, which as we spoke about just before, can be really hard to talk about for some people. So it gives you a new avenue of communication, especially with some people that might feel a lot of shame in talking about that. So that's just another example of a story card you can lay out that you can set out when you're working with clients with the use of like the Blurred Borders cards. If you want to jump to the next slide, thank you. So the Blurred Borders cards, we've actually got 3 different kinds of sets that legal aid has, and it's a set of legal communication tools. So we've got, so far you've just seen what the fronts look like in all of the across the PowerPoint, but we also have lots of information on the back, and the information that we present on the back of our Blurred Borders cards is actually in plain English. After we ran a huge engagement across Queensland to make sure we have universal languaging, and we cover topics across family violence, bail and criminal court, as well as health and feelings that we know come up often when people are struggling through the court system. So it is a tool for practitioners and lawyers and anyone that works with vulnerable people to pull out and use as a part of their communication tool set. We made sure that these tools are trauma informed, they're person centered, and what's even better is Legal Aid actually hosts 2-hour free training across Queensland to support anybody that would like to learn how to use these tools, and then actually get the kits at the end so you can go out, use them, and make sure people are getting the communication and clarity they need when they're talking about the difficult subjects in court and the law. So if you're interested in free training for the Blurred Borders kits, jump onto cle@legalaid.queensland.gov.au, send us an email and say, hey, I'd like training for this many people and this is the team that I want trained, and we'll look at setting you up with a training session. And the other thing is we do have all of our resources on the Legal Aid website. So if you liked what you saw today and went, wow, that was a really impressive, easy way to understand what these ladies have been talking about, you're welcome to jump on the Legal Aid website, look up Blurred Borders Queensland, and enjoy looking through all of the many, many resources we've built for it. Yeah, thank you.
How are we for time?
We have about 6 minutes left.
Sure.
I'm just seeing what other slides we have left to cover. We've got a few slides with resources and
Yes.
things. Did we just want to pop some links to these in the follow-up email so we can get through these quickly? So anything listed here, we'll make sure we pop in the email we send to everyone who registered for today's webinar when we send you a link to the recording. So we'll link through all of these resources and links the ladies have kindly provided. There's a few pages of them.
That's a lot.
And we'll also include a link to the Blurred Borders section of our website, as well as a list of upcoming training sessions and how to download all the free resources as well. We've got a few fact sheets there as well. They're also on our website. And when you, if you're interested in getting any of those, you can actually order them and have them delivered to you for free to your organisation. So we'll send links to where you can access those online, download, print or order copies to be delivered to your organisation. Okay, we've hit question time. A couple of questions have come through, so I'll have a look at those now. If you do have questions, pop them in the question box. We'll try to get through as many as we can today. Anything that we can't answer directly because it involves like individualised legal advice, we will follow up with you guys afterwards. So I'll just bring this up now and have a bit of a look and see what we've got. Oh, we've got a comment. Hang on, let's have a look. Thank you, Juhi. Juhi attended a Blurred Borders training session in March. It was great to learn about the cards and how to interact with clients. So thank you. We really appreciate that feedback. Let me see what other questions we've got. I've got a few here. I believe the PowerPoint in the materials bar is from previous CPD leaving cohesive relationships. We did have a webinar last week about leaving cohesive relationships. We will double check to make sure that the PowerPoint that was uploaded was the correct one. If not, we will make sure it's a copy of these slides that are sent to you with recording. So thank you for letting us know about that. I'll just see if anything else has come through. There's, no, that's all we've got for questions at the moment. If you do have any more, I'll keep scrolling down and check. At this point, that's all we've got. We've got a couple more minutes before we wrap up. So just while we wait to see if anyone has any other questions, I'll just run through our contact information. I'll go back and check the questions after. So on screen now, I've got our phone lines. So if you have a client that needs our legal help, they can call our 1300 65 11 88 phone line. That's our main phone line. They'll be answered by a client information officer who will assess what their situation is and possibly book them in for some free legal advice. We also have a Aboriginal and Torres Strait Islander information line. Now, this is a priority phone line. These calls are answered quickly in our call queue. So if you do have a First Nations client, we encourage them to call the 1300 6501 43 phone line. And the third one listed there today is for people who already have an application for legal aid that's been submitted and they're just wanting to check where that one's at. So that's the last one listed there. As I said before, there are heaps of free publications, probably about 80 free publications, legal information guides, brochures, all sorts of things on our website. You can download those, print them, or if you want physical copies, you can order them for free with free delivery to your organisation. And you can do that through our website, and we'll include a link to that in that email coming after this webinar. We run these webinars every month. We did 2 this month because it was DV Prevention Month, which has been great. Next month's topic, we are locking in the date and time, but it's going to be on sexual harassment and discrimination. So look out for that one. We'll send it out to our usual mailing list. So if you're not on it, please get on it and encourage your colleagues to do that as well. That is the end of our PowerPoint today. I'll just check if we have any more questions because we've got about 1 minute left. What have we got? I think that's everything. If any other questions get submitted that we haven't gone through, please just know that we will follow them up with you individually after this webinar. So we finished on time, ladies, so thank you so much to our 3 fabulous presenters today. Really appreciate you being here, and I hope everyone watching today got some useful information out of this, and we'll let you know when the recording is available. So thank you again for spending the afternoon with us, and all the best. Thanks very much. Bye-bye.